Good morning, everybody. Welcome to this month's webinar with 4J and Adam Moskowitz. We're going to just give it a few seconds here for everyone to trickle in. We had one of our largest registrations of any webinar we've done in 3 years. So it's very exciting. About almost 40 people registered for today's webinar. So we're really excited. I'm going to do a quick introduction to Adam here in a minute, and then we'll get underway. They were talking about all those thunderstorms yesterday, Adam. Nothing ever actually happened as a result. I don't know if you guys had anything over across the river.
Yeah, they were threatening all these storms, hail, and the end of the world essentially, but nothing ever matriculated.
Nothing materialized. Yeah. All right. So it looks like we have most people in, so we'll go ahead and get started. So thank you again, everyone, for joining us. Very excited for this webinar today. Couple housekeeping items before we get started. We've divided the webinar up into kind of 3 sections. The first is where Adam, our guest, is going to speak kind of high level on estate planning. Then we'll move into some Q&A between he and I, some discussion. And then the last piece will be an opportunity for you to ask questions directly to Adam, whatever is basically on your mind. So hopefully everyone can see our faces, hear my voice. If you can give like a hands up or a thumbs up, that would be great. So we know the technology is working. Okay, great. Thank you. And then the Q&A box, you'll hit that. This is the same as that. You'll hit the Q&A button on the bottom of your screen. You'll type in your question. You'll hit enter. It'll queue up for us. We'll be able to see it, and then we will relay those questions to Adam. So Adam is obviously an practicing estate planning attorney. He's been doing that for about 12 years now, and he actually heads the estate planning practice at Bregman Law Firm, BBS&G, which is headquartered over in Bethesda, Maryland. He went to GW Law. He continues to remain very active in his law school community. He teaches classes there, does speaking, and has mentored a number of young attorneys. So with that, I will turn it over to Adam to kind of start his presentation. And again, any questions you have, put them in the Q&A, and we'll make sure we get to as many of them as possible. Thank you, Adam.
Josh, thank you for having me, and thank you for the very kind introduction, and welcome to everybody. As Josh mentioned, I'm going to go over estate planning at a kind of high level. I want to make sure that we cover everything. I'll be sharing my screen momentarily. We'll go through a couple slides, and we've already received some great questions, which I want to get to, as well as the excellent questions that Josh has teed up, which I think will be really where you'll get a lot of very detailed responses and learn a lot. But with that being said, let me begin. I'll be sharing my screen so you can hear my voice. And let's make sure this works. Okay.
We see it here. Looks good.
Great. All right. So this is me. You already heard about me. Let's go to the next slide. Okay, so let's start off with some documents that really go along with everybody's estate plan. We call them the lifetime documents. These are the documents that during your lifetime may need to be used, typically when you are either incapacitated or incompetent. So there's a lot of different terminology for your power of attorney document. I typically call it a financial power of attorney. It's also called a general power of attorney or durable power of attorney. A lot of different names, but when you hear power of attorney, this is the document that I call the break glass in case of emergency document. Your power of attorney, your financial power of attorney, is only effective and usable while you, as the principal of the document, are alive. Okay, so it's only while you are alive. So if you are incapacitated or incompetent, and something financial or transactional needs to be taken care of, you are able to nominate and designate an agent as well as a backup agent to handle any of your financial and transactional affairs. A lot of people get it confused with the ability to use it after someone's passed away. It does become null and void after the principal of the document has passed away. It is a very powerful document. So if there's anything financial or transactional that needs to be taken care of while you are alive, but unable to handle it yourself, this is the document that allows your agent to handle whether it's whether you are buying, selling, refinancing, or leasing real estate and need to go to closing and sign documents, signing a check that only you can sign, signing a tax document, signing a form for Josh in a lot of situations, right? Or your wealth manager, or anything else, including a business document that may need to be signed. If you don't have one of these in place and you are incapacitated, the downside is that your spouse or whoever your agent is will not be able to use the document if it's not executed, and you'll have to hire an attorney to petition the court to open up an adult conservatorship to then have authority to handle that person's legal and financial affairs. So it's really important that you have it in place. It's also important that you freshen it up, I say, every 5 to 7 years. Many financial institutions or title attorneys, if it's for real estate, will consider the document stale if it's not a more recent document. And that's mostly because they want to protect themselves from accepting an old power of attorney that's been updated. So in order to give them some legal protection, they often will say, we want to see something more recent. And so that's one of the practical reasons I recommend getting this redone every 5 years or so. In addition to the fact that the language in the laws change in the statutory provisions that you want to see in there. Okay, so in addition to your financial power of attorney, there's your medical decision-making documents. There's a lot of terminology for this, which can be confusing. Living will, medical directive, advanced medical directive, healthcare power of attorney, natural death declaration. They all work hand in hand and they're all synonyms of each other. I really don't like using the term living will anymore because it confuses people with the last will and testament. The number of people that have said, oh, I left my children all of my assets in my living will, it's just really a confusing thing. So depending on the jurisdiction, there's different names, but really there's two things that are done with these documents. The first is, as you see here, you nominate an agent to act on your behalf, right? To make medical decisions for you if you cannot make them for yourself. It does not supersede your own decision-making ability. So don't be scared about filling these documents out and getting them executed. It does not take power away from you. I promise you, if you are able to walk into your doctor or into a hospital and effectively communicate what you want, you are still making your own decisions. So don't be concerned about that. It includes also end-of-life decisions, not just naming your agent, but kind of directing what to do at end of life, kind of codifying and certifying, if you want to be taken off life support, at the very end, and what your specific desires are in terms of pain medication. You need to check off HIPAA so that your agent can actually interact with your doctors and information can be exchanged. And again, as I said, every state has their own form. So as you work through it with your attorney or otherwise, just know that it might not look exactly like the one that your friend in New York has or your friend in California has. Every state works with the hospitals and doctors locally to make sure that it works as effectively as possible. Okay. All right, so here's where we get into the stuff that I'd say there's a lot of bad information out there, whether you're getting it at a cocktail party or on the internet. There's just so much information about wills versus trusts, and you may come across people and say, wow, I can't believe you don't have a trust. You must have a trust. I don't subscribe to that. I think that there's a time and a place for a trust. There are pros and cons to having a will-based plan versus a trust-based plan. And typically, when someone's talking about you must have a trust, they're usually talking about what's called a revocable trust or a living trust. I use the term revocable, but they really are, again, synonyms of each other. So we'll talk about probate in a moment. Well, let me just give you a high-level distinction here between wills and revocable trusts. So similarly, they're both drawn up and created during your lifetime. The will only becomes effective and usable after you pass away. That's when the terms of it actually make a difference. The revocable trust is a document, it is a vehicle that becomes effective during your lifetime for your benefit, where you are the creator, known as the grantor, the trustee, you are in control of the entity, the trust, and you are the only beneficiary. So it exists during your lifetime and after you pass away. A will-based plan is less complex. It's not focused on probate avoidance, which we'll talk about, and so it's often less costly. So some families who maybe are just doing estate planning for the first time, or if you don't own certain types of assets and you've named beneficiaries and you've talked it through and your family gets along great, there are circumstances where a will might make sense and you can save a few dollars. Otherwise, certainly as you get older, a trust makes more and more sense. And of course, the more complicated your family dynamics are, the more a trust can also make sense. You name if you have minor children, right, being under 18, that's where you would name the guardian. A trust does not name a guardian, only a will names a guardian. And the guardian is the person, if you and a spouse, if you have one, both pass away, the guardian is who would take over as a parent for your minor children, right? Who makes sure your children brush their teeth, go to school on time, get dressed appropriately, eat their vegetables. It's a parent role. And that works kind of hand in hand with a trustee if a trust is set up for your children. The downside to the will is that if there is probate, it can take up to 9 months to a year, including filing final tax returns, which happens the following year after the decedent passes away. If you have an estate attorney who knows what they're doing, it can often be more efficient than if you try to do it yourself or with an attorney who doesn't know what they're doing. We've seen that a lot. A revocable trust completely avoids probate. That's one of the biggest benefits. And the administration can take 6 months or less, really depending again on the family structure and whether there's ongoing trust or not. Both documents can be amended or replaced during your lifetime. The revocable trust, that's why I like to call it the revocable trust. It highlights for you that you can revoke it, modify it, terminate it, change it, amend it whenever you want, right? As the creator, grantor of the document. Wills can create subtrusts. With a lot of families, we'll create subtrusts just in case maybe the parents pass away. It's not likely because they're young, but maybe they have minor children and we want to protect those minor children from a lot of things that we'll talk about. And a revocable trust does become irrevocable after the creator or creators, again known as the grantors, pass away. So the document does become irrevocable and unchangeable when the creator, grantor passes away. All right, so here's a little blurb on probate. You can read it. When I speak in large groups and when I talk to clients, I like to kind of give some imagery, some more descriptive terms. This is the way that I describe probate. What I start by doing is saying, I'm not your wealth manager or financial advisor, and we'll talk about that later. My job is not to make your money go up in value, hopefully. I'm not your CPA. I don't file your tax return. As your estate attorney, my job deals with the direction of your assets. And as far as I'm concerned, you have two types of assets. In the simplest version, you have two types of assets. You have assets that when you pass away have direction, meaning those assets know where to go automatically. And you have assets that when you pass away do not have direction, meaning they do not know where to go automatically. So if you and let's say a spouse own assets jointly, whether it's real estate or a checking account or an investment account, and one of you goes poof, which I'm sorry to be morbid, but it's my job. I guess that's the nicest way of saying it. So one of you goes poof, the surviving spouse is the surviving owner of the asset. And by law, they automatically become the owner. That asset has direction and knows where to go automatically. There is a surviving joint owner. From a legal perspective, it's really that simple. Similar idea with a pay on death beneficiary. Consider a retirement account like an IRA or 401k, or maybe a thrift plan if you're in government, or a life insurance policy. You have that account, you name your spouse as the primary beneficiary, you go poof, that asset knows where to go automatically. There's a surviving pay on death beneficiary. Depending on how your assets are titled, whether you're single or whether you're married, whether you have children or no children, whether one of you passes or both of you passes, certain assets will not have direction when you pass away. Not always, but in many cases. So let's say that you're a single person or you're a couple, and either you as a single person or both people in the couple pass away at the same time. Many of your assets will not have direction. Let's say you're the only owner or owners of your home. There's no pay on death beneficiary and there's no other owner. That asset would not have direction when you pass away. There is no surviving joint owner and there's no pay on death beneficiary. Assets that do not have direction when you pass away go to purgatory, which by alliteration we call probate. So that's what probate is. Probate is only for assets that do not have automatic direction when you pass away. Your last will and testament is what gives direction to your probate assets that do not otherwise have direction. Here's the key. Your last will and testament only gives direction to your probate assets that do not otherwise have direction. So when you hear about families fighting, a lot of times it's because people don't understand this. If Josh and I are brothers, maybe we're the only two children of our parents, and I'm the nefarious one. Josh is a very nice guy, as we all know. So I'm the nefarious one, and I'm the one who maybe unduly influences our parents or a parent into naming me as the pay on death beneficiary on retirement accounts, on life insurance policies, on investments, even though mom and dad's will says when we're gone, 50% to Josh, 50% to Adam. If those assets were given direction to go to me only automatically, the asset never goes to probate, and therefore the will has no power or purview over those assets. So effectively, Josh doesn't share in our parents' estate 50-50. Okay, he would only share 50% of the assets that went to probate because they did not have any direction by virtue of joint ownership or beneficiary designations. And this is pretty common. So estate planning with property in multiple jurisdictions. If you own real estate in multiple jurisdictions, this would be another reason to use a trust in addition to all the other benefits we talked about. The reason is that if you own real estate in multiple jurisdictions, you may have to do multiple probates, right? So if your real estate is owned by your revocable trust, your heirs, your successor trustees will not need to do multiple probates, also known as ancillary probate. So that's another reason to use a trust. So again, revocable trust, also known as living trust. You can revoke it, terminate, amend it, restate it. It can be a joint trust if you have a lot of joint assets as a couple, which works well depending on the jurisdiction, or separate revocable trusts. To go a little detailed, we're seeing more and more joint trusts, as we'll talk about estate taxes later. The federal government, as well as Maryland, but not DC, Maryland and Virginia has no estate tax, which we'll talk about, have come up with something called portability, which allows couples to combine their estate tax exemptions more easily without using separate trusts. So that's one reason we're seeing more joint trusts. Again, probate avoidance. A question that always comes up is, well, will the revocable trust make my life more complicated? It's another entity. It is not an entity for tax purposes. It's kind of like a see-through entity, like a single member LLC. You can think about it that way. A revocable trust has no separate tax ID number. It uses your social security number for tax reporting. So there is no separate tax return or taxes. That is something that makes it less difficult and complicated to use a trust that people might be concerned about. Another benefit that I haven't mentioned yet is privacy. A will, as you've probably surmised because it goes through the court system, is public. So anything you put in the will is technically public record. A trust is a private document. No one is entitled to it unless they're actually named in the document. People also get confused. Well, if I have a trust, why do I need a will? Well, colloquially, we call the will, if you have a trust, a pour over will, P-O-U-R, because if something sneaks by us, we want a safety net in probate. And so the will would pour over the assets into the trust. Okay, so the trust is named as the beneficiary in your will, and the will becomes a lot less complicated. Again, it's a safety net. There are complex trusts, not something we're going to go into a deep dive with today, but for different reasons, there are different types of trusts, whether it's for kind of dynasty, multiple generation planning for very high net worth individuals. And that kind of also differs depending on the state you live. Irrevocable trusts, there's very limited ability to amend those. They are a separate entity, which gives you protections in certain situations, creditor protections, protections in blended marriages, tax protections. There are reasons to have complex trusts. A blended family is something called a Q-tip trust, which allows you to have control from the grave to make sure that none of your children are disinherited if you are in a blended family. There are estate tax planning trusts, which allow you to get assets out of your estate for tax purposes. There's life insurance trusts, which you may have heard about, called ILITs, which can be very useful. And those are heavily used. If you or someone in your family is on government benefits, SSI, SSDI, for example, and it's means tested so that that person cannot inherit assets or have a certain number of assets, you can create a special or supplemental needs trust to protect government benefits. And then there's all sorts of charitable trusts, as well as maybe a donor advised fund that Josh may or may not talk to you about at some point, which can have a lot of tax benefits as well. But again, not for today's discussion. You can talk to Josh and or myself about that in the future. One of the biggest pitfalls in estate planning, and Josh and I talk about this a lot, is designating minor children as beneficiaries on assets. You do not want to do it. Whether it's your retirement account, life insurance, and I'm talking not just about primary beneficiaries, which if you have a spouse, you should name your spouse. I'm talking about backup and contingent beneficiaries. So if you're a couple and you have two minor children, and there we can go, I'm a big nerd, so we can go as deep down this as you want, but basically, if you both go poof and you have minor children and you've designated them just in their individual names as the backup or contingent beneficiaries on accounts, minors cannot inherit assets. And so what has to happen is the guardian has to hire an attorney to petition the court to get a court order to open up a restricted guardianship estate with the financial institution to inherit the assets on behalf of the minor child. Every single time the minor child needs anything, whether it's braces or a backpack or a new winter coat, anything, the guardian has to hire the attorney to petition the court to get a court order to bring the order to the financial institution that holds the guardianship estate assets to release the funds to pay for it. It's miserable and it's expensive. You also have to hire the attorney to file an inventory and an accounting every year with the court, which is additional cost and stress, really. And then at age 18, the child receives all of the money outright. So one of the things that we spend a lot of time thinking about is not just minor children, but once they become adults, or if they even are young adults, preventing them from being out into the world where in this situation, this hypothetical, they're orphans, maybe some challenges that they're having emotionally, psychologically. Now they've inherited all this money outright at age 18. We want to prevent them from spending frivolously, from being taken advantage of in a romantic relationship, and or in a friendship, right? Friends taking advantage. So there's things that we can do to protect from all of that. Something that you'll see more and more is the Secure Act. The Secure Act passed in 2020. Secure 2.0 has come out. I'm still doing a lot of reading. This is something I specialize in, and how regulations are affecting exactly how we inherit retirement accounts. That's what the Secure Act is about. When you hear Secure Act, it's about how do we inherit retirement accounts. That's the part you want to focus on the most. It does do some other things. It's extended the time in which you need to start taking your required minimum distributions. I believe they're up to 72, but that's scaled up to, I think, 75. So I think now it's 72 and a half, could be off by half a year. It's going up to 75 over the next couple of years for when you have to start taking your retirement distributions. but it's all about how inheriting retirement accounts. So the new rule is, because Uncle Sam wants to collect his tax dollars more quickly, if you inherit a retirement account, the account has to be essentially liquidated and distributed within 10 years from inheriting the retirement account. If it's a Roth account, not as big of a deal. But if it's not a Roth retirement account, then that's all pre-tax dollars, which can be a huge tax hit. And you really, really, really want to talk to Josh if you have a retirement account of any size and/or you are inheriting one. It's more complicated than you would think, and you want to make sure that the money grows income tax deferred for as long as possible. There are exceptions: a spouse, someone on government benefits, some types of siblings, which is kind of more something we can talk about in the future, and then minor children only of the decedent. But what's complicated about that is that there's a pitfall. If you name your minor children outright and it goes into a guardianship estate, you actually lose years that it can grow income tax deferred. So you want to use something called a conduit trust or another type of trust that is for the benefit of the minors. The retirement account can end up there, and the money can grow income tax deferred for as long as possible. Very quickly on estate taxes, something that we can talk about more in the future. Currently, the federal threshold for paying estate taxes is $13 million per person. With portability, that's combined essentially automatically. That is due to come down to somewhere between 5 and 6 million per person in 2026. As I'm telling clients, and this is apolitical, it really depends on who wins the next election, whether it's a Republican or a Democrat, and if they have coattails for Congress, to determine if that estate tax exemption will stay high or come back down. That's my opinion. We'll see what happens. Virginia, very quickly, there's no estate tax, so you're just focused on the federal estate tax. Maryland, there's an estate tax, 5 million per person. They do have portability, so as a couple, you get 10 million. DC, it keeps shuffling between 4 and 4.5 million, but let's call it 4 million per person. There is no portability. So if you live in the district, we should talk. You want to make sure that we're utilizing a special type of trust to be able to combine your and your spouse's estate tax exemptions. All right. As I've alluded to multiple times, if you don't have your team together, you're doing your family a disservice as you get older. You're also probably doing yourself a disservice. You really want to make sure you have the 3 legs of the tripod: the estate attorney dealing with the direction of your assets, your wealth manager or financial advisor, making sure that your assets are titled correctly, beneficiaries, that your assets are growing in the way that you want them to. Again, that's not something I get involved with. And then your CPA and accountant to make sure that someone sophisticated is filing your returns. And I'll tell you anecdotally, it's super beneficial when you have this team together, because when you're gone, if your family can just call the accountant and the accountant knows what your tax return has looked like the last 20 years, it makes things a lot easier to deal with and to file those returns, including any estate or fiduciary income tax returns in the future. That institutional knowledge of your life can be very beneficial and save everyone a lot of time and money. So my 20-ish minutes is up, and I want to offer the Q&A part.
Perfect. So yes, there have been multiple questions that have come through in addition to the ones we got ahead of time. So before we get to those, which we definitely will have time, just want to thank Adam again. That was a great presentation, very clear, very well articulated. So I think that was great. One thing I just want to go back to, just a question that you can kind of go through with us is, let's say my spouse and I never merged our bank accounts. So we have our retirement accounts, which, are what they are, each other as beneficiary, but each of our checking accounts, let's keep it really simple, is owned individually. Okay. And we have a last will and testament, let's assume no kids. She pays certain parts of the bills out of her account. I pay certain parts of my account, but individually owned. I die. Let's say I'm paying the mortgage and things like that in my account. Because she's not a joint owner on that, but we are married, how would that work? How quickly would she be able to get access to that account to pay those bills? Can you just walk us through kind of what would actually happen in that kind of a situation?
It's a great question. It's very common. My spouse and I, we have certain assets that are joint. We have certain assets that are separate. My best piece of advice off the top is, if you don't feel comfortable adding your spouse as a joint owner of an asset, try to add them as the pay on death beneficiary. Because that way, let's say you have an account with Josh and you don't want to add your spouse jointly, Josh can very quickly, once you get the death certificate, right? Again, sorry to be morbid, but once you get the death certificate, the account can very quickly be retitled into the surviving spouse's name. If there is no beneficiary, then you run into the issue where it can take a little bit of time. It also shows the real value of having an estate attorney that your family's been working with, because A, you'll get this advice ahead of time and hopefully this won't be an issue. But if you have a go-to estate attorney or someone that you can get in touch with, hopefully, they can be more efficient in getting your spouse's estate open quickly, getting the letters of administration from the court, and using the letters of administration, a tax ID number for the estate, and the death certificate, we can get that asset distributed to the spouse pretty quickly, but it's still going to take a couple weeks at minimum.
Okay. So in a worst case scenario, the surviving spouse would have to use their own account to pay those bills, or worse yet, tap the retirement accounts. But with a good estate attorney and having things teed up quickly, it could be done far quicker than the 6 to 9 months that it normally takes.
Sure. Yeah. And if the surviving spouse doesn't have the liquidity, that can become a concern. If either you decide you just don't pay those bills for a while and you pay interest or penalties, or maybe you have to take out a line of credit to get fronted the money, or borrow from a family member. So yeah, there are ways to do it, but it can be sticky.
Okay, that's super helpful. I think you kind of touched on this. One of the things kind of within our office we were talking about before is, and Adam kind of walked through, if you do die intestate, what are the issues that creates? I feel like you kind of touched on that. I don't know if there's any other stories you want to mention or things to highlight.
Sure. So intestate or intestacy means that you have probate assets, but you don't have a will, right? That's what intestate means. And I'll tell you, you can run into issues. I'll give you a good example. Every state has its own intestacy laws. I'll give you 2 cases that we're working on now. There is a case where we believed initially we did not have a lot of information that the decedent passed away domiciled in Maryland without a will, but it turned out that he was domiciled in DC. It was a kind of a complicated case. The laws of intestacy were different because we had to use an air search company, HEIR, to find out who the closest living relatives were. And the closest living relatives were first cousins. And in Maryland, the surviving children of predeceased first cousins participate like a first cousin would in the intestate estate. But in DC, they don't. Only the surviving first cousins participate, and the surviving children of a predeceased first cousin does not. So we had to basically tell a group of people that thought they were inheriting assets that they were not. So that's the highlight, that the laws are simply different. I'll give, in a situation in DC, under the intestacy laws, there was a young couple. Unfortunately, the wife passed away and the husband reached out. They had not gotten their wills in place. It was an intestate estate. The couple was estranged from the wife's parents, but under the laws of the District of Columbia, the spouse gets a large percentage of the intestate estate, but the decedent's parents also get a portion. So we had to include them in the estate administration, and it got very nasty. So it's really the jurisdiction determines who receives what from the intestate estate.
Very helpful. Have you come across any issues? Let's say you have a single person, no kids, and everything is titled with a beneficiary designation, right? Even if it's a non-qualified, non-retirement, they have the POD, TOD you talked about. Have you seen any issues around liquidity for paying for funeral expenses or otherwise settling the estate that can emerge there?
That's a great question. It's probably one of the best questions because I have a term for that. It's called over-planning. And some people decide to do that. So let's say that I'm a single person and I don't really have any family to speak of. Maybe my parents have predeceased me. I don't really have any communication with, maybe my one sibling lives across the country and we're estranged, no spouse, no kids. And I've decided I leave all of my assets to maybe charities or to, a family friend or someone. And that happens. So what happens is I go poof, and someone needs to step in, there are a lot of debts, taxes, liabilities, and expenses. Funeral expenses, final healthcare bills, my utility bills, my final income taxes have to be paid the following year, the income tax preparation fee from the CPA, the legal fees, my credit card bill, right? All of these things that need to be paid. And as Josh can tell you, if the friend shows up with the financial institution and says, well, I'm the beneficiary, here's a death certificate, the bank doesn't say, well, let's hold some money back to make sure that that the expenses of the estate can be taken care of. They're just going to transition the account. And same idea to a beneficiary. So sometimes you run into situations where if you overplan, there's no liquidity to pay for these things, and the estate can become quite a mess. Or, your affairs just don't get wrapped up, and your assets are gone, and there's really no one to take care of you in your final matters.
That's very helpful. Maybe last question here, and then we can pivot to the client questions. What are the biggest, if you were to highlight top couple biggest pitfalls you see with estate planning, either just knowing what's out there or that where you've actually dealt with it because they've come to you with these issues? Is there anything you could kind of summarize it?
Definitely. So it's something we've talked about. Biggest pitfalls: designating minor children or immature young adult children as beneficiaries or even backup beneficiaries directly on assets. That's a huge pitfall that we talked about. Over planning, which we just talked about, not making sure that there are assets left behind to take care of your final debts, taxes, liabilities, and expenses. Another one that we mentioned, which is if you own real estate in multiple jurisdictions, using a trust to avoid multiple probates. Other big mistakes are simply not communicating with your advisors. If you move, you have children, you have grandchildren, someone passes away, you come into a good amount of wealth, you get divorced, anything, make sure that you're communicating with your advisors. That's why I generally like to work on a flat fee when I'm doing estate planning. I want clients to communicate with me. I'm never going to send a bill for an email saying, hey, can we talk for 5 minutes? This, changed in my life. Something's evolved for the better or for the worse. You need to communicate. So those are some of the biggest pitfalls. And then, of course, if you are of a certain wealth level, again, anecdotally, people will come in and they'll say, even though they're very wealthy, you're often wealthier than you think you are because all of your assets liquidated can add up to a large amount of money. People come in and say, well, I just need really simple. Just, I've never done this before, but, just keep it really, really simple. And the truth of the matter is, if you do want to do some tax planning, it's not really simple. And we need to be able to engage on those topics.
Okay, great, fantastic. Let me start with a question that came in ahead of time. So great question. Says, I am listed as a tenant in common on a condo title that was purchased with my mother together in 1980. She is now 92 and thinks I should come off the title and leave the condo to me in her will for tax reasons, and when I sell the condo after death. Are there any legal restrictions to changing the title? What route is best? Should we leave it as is or remove me from the title? Are capital gains any different when I sell as owner or as an inheritor?
It's a great question. So if you own real estate with someone of an older generation, here are the things you want to be thinking about. Okay, so obviously it sounds like this property was purchased a while back and it has likely appreciated in value. The two, you and that person and their parent are co-owners. And so if you are to gift the whole property, your half of the property, to your parent, that is considered a gift. You would want to let your CPA know, because it is considered a lifetime gift against your federal state tax exemption. That's a Form 709. If you are not, very wealthy, or even if you are, it could be a good option for you, because if you're not going to hit a state tax exemption, if you're not going to hit a state taxes anyway, make the gift. And the idea would be that the basis, let's say that the home was purchased for $100,000 and maybe now it's worth $750,000, right? Real estate has appreciated a lot. You might think, oh, well, when this person inherits the whole house, it was bought for 100,000 and they sell it for 750,000, they'll pay capital gains taxes. Putting the credit for being a principal residence aside, from a very high level, if your mother or your parent, I think it was a mother, but if your parent owns the property 100% and you made the gift and you inherit the asset from your parents' trust or from their estate by the terms of the will, there will be what's called a step up in tax basis. So now you will own the property when your parent is gone. It's worth 750,000. The tax basis is 750,000. So if you sell it, guess what? Zero capital gains taxes. So there could be a tremendous benefit to allowing your parent to own the property outright, and inheriting it from them in a couple of years, or whenever your parent does pass away.
Super comprehensive answer and very clear. So thank you for that. Okay, I'm going to go to the queue here. I think we kind of answered this, but does getting married override defined beneficiaries on accounts? And I know that is a little bit of
it's a great question. It's a great question. So the question is, if you're married, but you designate someone else as the beneficiary of an account. So let's say, for example, and this may be a common scenario, and maybe I'll try to use myself as a hypothetical. So I have two siblings, and let's say that I have an old Roth IRA that I started years ago, and it's a premarital asset, and I still have my sisters named as the beneficiaries on the retirement account. And I'm married. The rest of my assets are either joint or I've named my spouse as the beneficiary, but not on that account. The beneficiaries named will override anything I have in my will. But of course, because lawyers like to make things complicated, that's the rule, but there's always an exception. And the exception would be, depending on what percentage of my total assets I end up leaving to my spouse, there is something called the elective share. And that's in place so that you can never completely disinherit your spouse. So depending on the jurisdiction, just generally we'll call it a third. That's usually what the elective share is. So let's say that I just became disgruntled with my spouse. I changed everything on my beneficiary designations to maybe my kids or my siblings and left nothing to my spouse. My spouse would be able to make an elective share and ultimately get a third of my assets, no matter what the beneficiary designations are, and no matter what my will says. So that is something to think about. But generally, the beneficiary designation supersedes the marriage.
Super helpful. And I don't, if this is overcomplicating, then say so. But if it's an ERISA plan, like a 401k, and I've listed a sibling, is there an exception there where they could file something and say, oh yeah, this has to go to the spouse because they didn't sign it or something like that?
Yeah. So you actually might be a better person to answer that question than I am. But in my experience, sometimes people let's say your sibling, or even worse, right? You've probably seen this. Your ex-spouse is still named as the beneficiary. Sometimes people don't get the chance to update it. Now, what Josh is alluding to is the fact that, let's say that I get married and I start working somewhere and I have a 401k. A lot of 401ks will not allow you to designate anyone other than your spouse unless your spouse signs a waiver, which maybe is something that's been negotiated in a prenup, or for whatever reason you agree to do something different. But certainly I've seen that if you're signing up for a new 401k and you are married, you have to name your spouse. But I don't know exactly. That's why I said you might have more information than me. If the account's already been established and the beneficiary's designated, and then you get married, I don't know that it gets on anyone's radar enough to change it, which is why you do hear these horror stories of people still having their ex-spouse as a beneficiary.
Yeah. No, I think that suffices as an answer. I mean, we don't need to go into every possible rabbit hole. So I'm going to keep going with the next question. So, and I think we answered this, but what does jurisdiction mean in the context of the trust? Is it 2 different counties, 2 different states? And I think it's state driven, right?
It is state driven. The only thing that matters from a county by county perspective is that there are local rules. they're not usually very different, but whether, let's say you're in one county in Virginia versus the other, or one county in Maryland versus the other, obviously DC is one jurisdiction. So sometimes, whether it's the clerks, sometimes they want to get a little more information, or sometimes the auditor is a little tougher than the other, but that's really more of a personnel thing. So there are some differences in the county by county, but when I say jurisdiction, it really does mean state by state.
Okay, helpful. Is a Q-tip trust a separate trust or part of your overall trust documents?
Great question. It can be set up as a standalone trust. It usually though, let's say for example, that you are in a second marriage and you have children from a first marriage, you would create your own irrevocable trust. And then when you pass away, your trust would have a sub-trust built into it, which would be the Q-tip trust, so that those assets would continue in trust for the benefit of your spouse. And then you can ensure that whatever's left of that trust goes to your children, whether it's only children from your first marriage or whether it's all of your children equally. That's something you would decide. You have control.
Excellent. Individual says, we have multiple financial accounts in life insurance. How is that divided between multiple heirs? Does the executor handle that?
So again, you would determine if you have pay on death or transfer on death beneficiaries, that would be you deciding. If the asset, if you pass away and the asset does not have any beneficiaries that survive you, it would be your will that determines that. If we met, I'd probably talk to you about a trust so that you could retitle certain assets into the trust. You could also name the trust as the pay on death beneficiary, so that then you have one document that's dispositive of who gets what and when, and you could have everything flow through the trust and avoid probate. If you're over the estate tax limit, we would probably talk about moving your life insurance policy into an irrevocable life insurance trust for estate tax planning.
Question. This is a good open-ended question. How do you recommend that one chooses an estate attorney?
I think often, it's a great question. So I think often word of mouth is the best. If you have a professional that you trust, whether it's your CPA or your wealth manager, like today, when you're an estate attorney, a wealth manager, or a CPA, you often come across a lot of different professionals, and you can really kind of see, who works well with clients, who's client focused, who's sophisticated. And if your advisor is recommending someone to you, that's usually the best way to go. You also, of course, can do your due diligence, go to see if they have Google reviews, check out their website. You can also ask friends and family. A lot of times also, as Josh could probably tell you, maybe someone from an older generation is passing away, and or they're just getting older and they're putting their affairs in order. And you might just continue to use your parents' advisors. Be careful, right? You don't want to use someone who's maybe on the verge of retirement themselves, but certainly, if there's a firm or an attorney that your parents or aunts and uncles or someone is using that they really, really like, and you've seen the process go smoothly, that would be a good person to talk to as well.
Excellent. So if back to that example real quick with the person who owns the property with their mother, and they go through and they gift it, then it would pass based on, it'd be just in her name, so it would pass based on her last will and testament, which would go through probate. The person's just asking this follow-up question, but yes, it would go through probate, but it would be based on the direction of what the last will and testament says, so it would ultimately get to that individual.
Correct. And what I would, again, without knowing more, what I would generally recommend is that the adult child gifts their half to their parent, right? We button that up from a CPA perspective, so then the parent owns the property outright. And then maybe what we would do is put it into a relatively simple revocable trust for the parent. And then that way, the surviving child, without any probate, automatically would get the property. But of course, that's it is a little bit of work, but if you can save a lot of money in capital gains, it's worth it, because in that scenario, you'd be doing 3 separate deeds. You'd be deeding the half interest to the parent, gifting the parents then full interest into the trust. And then when the parent is gone, you have to deed the property to the child. But for the whatever the cost would be, which is, would be nominal, immaterial compared to what you could save in capital gains taxes.
And then there is a question here where they're using an abbreviation. So I don't know if you'll be familiar with this. I think it has something to do with advanced care planning, physician's order for life-sustaining treatment. Please discuss Virginia's physician order for life-sustaining treatment and the relationship to Virginia estate planning.
Sure. No, the POLST and Maryland has the MOLST. And so people do ask about that. So your medical decision-making document is really the document where you're making the decision about who is your agent for interacting with your doctors and hospital, if you cannot make decisions for yourself. This POLST is where you can make some distinct end-of-life decisions with your doctor. So it's something that your physician actually signs in addition. So they kind of work hand in hand. I'd say it's almost like a booster to your documents. It's not something that's always completely necessary, but a lot of people do find it very comforting that they've had the discussion with their doctor has certified these things. And one thing that I do offer when I work with clients is going through the document with them. Maybe there's a question about the interplay between your other medical documents and this document, and also highlighting for you some of the issues to think about, and even maybe give some advice and discussion on what to talk to your doctor about when you do go to get them to sign it. But in my experience, a physician's signature is needed on that.
Awesome. Questions keep coming in, so you're doing well, Adam. If my estate documents list a residence and then I move to a different state, are new documents required?
This is a great question, because there's a lot of examples I use. So a lot of people come to me with either outdated estate plans or estate plans that were never fully formed, in my opinion. And on a lot of trust documents, you'll see an exhibit. I don't like to use them because attorneys will say, okay, here's your exhibit A to the trust, and this is what's in the trust. It often is wrong. I could create a trust and put exhibit A, I could put the White House and Josh's house and anything I want on the exhibit list. But unless the title of the financial account is in the name of the trust, or the deed to the property is in the name of the trust, it does not matter what my estate documents say are the assets of the trust. What is dispositive, the most important thing, is that the titling of the asset, whether it's a financial account title or a deed title, that says it's owned by the trust. That is what determines what is owned. So to answer your question, let's say you live in Virginia and you created a revocable trust and your Virginia property is in the revocable trust, and you move to Maryland, you don't need to do anything more with the property. It's still owned by your revocable trust, and will still make sure you avoid probate in multiple jurisdictions. You may want to have your trust kind of poked at because the trust situs is moving from Virginia to Maryland. But in terms of the real estate, it's great. You don't have to retitle your deed again if you move. If you still own the property, right? A lot of people, if they move, might sell the property, right? So of course that would be moot. But if you keep the property, yeah.
All right, that's really helpful. So someone also posed the question of, can you just talk about owning your home as a TOD versus a trust?
It's interesting. So there are some jurisdictions where you can name a beneficiary on real estate. I will tell you anecdotally, most title attorneys I talk to will not do these types of deeds for a lot of different reasons. One of them is because it can sometimes confuse your insurance. That's one of the small reasons. It also sometimes conflicts with your mortgage agreements. And it also lends itself to over planning. So you might think you're being, smart about saying, okay, well, I can make sure my house avoids probate and goes directly to this person, whether it's a child or a niece or nephew or whoever it is. But if you've overplanned and you have no assets in your estate, it often can become an issue, and a lot of people could essentially get sued, or the government could try to claw back assets, and it can make more of a mess than you expected. Anecdotally, I had a case where someone pulled one of these types of deeds off of Rocket Lawyer, which we can have a whole other conversation about. And they thought, because when you go to Rocket Lawyer or LegalZoom, you don't actually get legal advice, and if you want it, you have to pay for it, and it's usually not very good. But I'll put that aside. They downloaded one of these transfer on death deeds in DC, and they didn't read it right, and they filled it out and they got it notarized, but they never recorded it before the person passed, and so they spent money on it and it was ineffective. So there are pitfalls to it, right? Because even if it could potentially work in your situation, you still want to make sure that the procedure is being done correctly. So I would say talk to your attorney, especially your real estate or title attorney, about it before you do it. Because remember, also, you have, when you buy a home, you get title insurance, and you want to make sure that that's not conflicting either.
Just to keep going on that, let's say the husband owned a home, and they got married later in life, and the spouse moved in with them but does not own the home, and they have a child together. If they don't have updated estate plan documents and the husband died and he owned the house, but it's right, he's dying intestate, or however you said intestate, what would happen to her with
if it was intestate, then the surviving spouse, because the intestacy laws, it would potentially be split, right? A surviving child, depending on the jurisdiction, might get a portion. So now the spouse might end up only owning maybe 3/4 of the home, and then there's a deed where the child owns 1/4 of the home. And if they're a minor, that presents more issues. So two things: one, in a limited circumstance, a TOD deed on a property to your spouse might be okay. I think that's kind of where you were getting at.
Yeah.
What I would recommend is that if you're up to it, even easier, since you're doing a deed anyway, is add your spouse as a joint owner. There is a special type of ownership for married couples. It's a type of joint ownership called tenants by the entirety. And if you're married, you probably own your home tenants by the entirety. And the benefit to that is you get a very special type of creditor protection. So let's say that I get married, I add my spouse as a tenant by the entirety owner on the house, and I get sued for something. I get a huge $10 million judgment against me, and I'm not worth 10 million, right? All my assets are privy to it or subject to the judgment, but not my home. There is a creditor protection if you own your home tenants by the entirety with your spouse, and unless you and your spouse are both subject to the judgment, it's protected. So I always recommend that.
And when we set up like joint investment accounts, if they don't have a trust, we do same thing, tenants by entirety. Does that offer in Virginia the same protection as is, or just specific to a home?
Great question. So, and I'm happy that you guys do that. Some financial institutions don't offer that. And so what you want to do is you want to own your real estate and your joint investments, tenants by the entirety. And if you then transfer those into your joint trust, it not only do you avoid probate and get privacy and all these benefits that we've been talking about for the last hour, it also maintains the tenants by the entirety protections if it goes from a tenants by entirety account into your joint account. I'm sorry, into your joint trust.
Interesting. But okay, I know we're nearing the end, this is good. So if it's joint tenants with right to survivorship, and then you transfer into the joint trust, you would
Correct.
want to change.
So if you own joint tenants with your spouse, you want to convert that into a tenants by the entirety account and then move it into your trust, and it would continue to get the tenants by the entirety protections. Beautiful. And the trust benefits. Yeah.
Beautiful. That's awesome. Right up to the wire here, Adam. Lot of good questions. I mean, 10 questions plus some in advance. So I think we're going to have you back at some point. This seems like it was a big hit and helpful for us as well. So thank you for taking the time and doing the thoughtful presentation, the preparation. And it was just, I think, a big success. So we really appreciate it. And how can people get a hold of you or find you?
Definitely. I'm not sure if my screen is sharing or not.
It's not right now. It's not right.
Okay, so let me share my screen quickly. And this is my contact information at the firm. If you can email me, you can call me. If you Google my name and the name of the firm, all my contact information is on the website as well. And of course, make sure you're communicating with Josh periodically. because he has a lot of great information that you want to have with your investments. And then you can also ask him for my information as well.
Yeah, Adam's incredibly responsive, response within, definitely same day, sometimes same hour. So he's one of the most responsive we've come across, which is a huge deal when it comes to, estate planning, wealth management. So thank you again. This was fantastic. And hopefully we'll see you back soon. Appreciate it.
Thank you everyone for joining, and thank you for having me.
Awesome. Thank you, everybody. Take care now.